Well, welcome everyone. I can't exactly see you because I'm locked in the slideshow, and so your faces don't appear. But I saw a lot of familiar faces, a lot of wonderful people, and we thought at MEIC it would be useful to do a Hardrock mining update because some significant events have happened very recently, and this is a core part of our program work. And so I intend to go through some of the major highlights and answer any questions towards the end. Although one of the first things I'm going to talk about is the Smith River and the litigation surrounding it. And I suspect there's going to be some burning questions there. So I'm probably going to take questions at the end of that segment and then go to some of the other issues that we're grappling with. And then we can take a full suite of additional questions at the end. You can drop your questions into the chat, or I'll ask for them once we get a little towards the end of the Smith discussion and then towards the end of the presentation. So if I didn't introduce myself, my name is Derf Johnson. I'm the staff attorney at the Montana Environmental Information Center. And I'm also the person who's chiefly responsible for all of our different hard rock mining work, which we as an organization have worked on for, well, almost virtually since our inception, but we have a very active hard rock mining related program, including for the past 8 years, I've been responsible for 8 or 10 years for working on the campaign to prevent a hard rock mine, a copper mine, at the headwaters of the Smith River. And I don't think that it's any secret that we had a really quite incredible victory a couple weeks ago, in which a Montana District Court judge issued an order that was pretty much wholly in our favor regarding our legal challenge of the permitting of that mine. And I'll get into the details of this, but I think that what I wanted to do here was thank everyone. This could not have happened without a team effort, including all of the people who showed up at the hearings that we had, who submitted comments, who showed up at the legislature, who sent us money, who helped our partners, because we had partners in this big victory. It was a really, truly a team effort. We ultimately, I got a thing here, 12,600 comments on the environmental impact statement process. I can't remember the number of public hearings that we had, 3 or 4 on that process, and then we held our own. We had a ton of press. We did, we did city council resolutions. We really pushed this issue across Montana with MEIC and our partners, and ultimately that certainly helped in creating an atmosphere and in creating a place for this judge to rule in our favor. And she just did so a couple weeks ago. That I'm going to dive into the details here now, but I just wanted to thank everybody, all of our members, all of our supporters, and our partners, Trout Unlimited and Montana Trout Unlimited, Earthworks, and American Rivers, and of course Earth Justice, because we had a really fantastic coalition. This fight is not done, and I'm going to touch on that again, but I just wanted to take a moment and pause and celebrate a pretty resounding legal victory. So what did the judge say? It's actually a fairly extensive order for a district court judge to be issuing. I think it was close to 50 pages. And these are the major flaws that she found in the permit during her review. Ultimately found that the issuance of the permit was arbitrary and capricious and not in conformance with the law. And so I just wanted to go through each one of these really briefly and just explain it to you so you understand what it is that she said. So in terms of the stability and safety of the tailings facility, she found that the DEQ did not adequately evaluate its stability and its potential for really failure through what you would call either a geochemical related wearing down of the cement or through flowability. So for the flowability aspect, DEQ had authorized a 0.5% mixture of cement tailings. And that was not evaluated. What was evaluated was down to 2% tailings mixture. And that is concerning because the less and less cement that you are add into this mixture, the less stable and the longer drying time that it requires. And DEQ just wholly didn't address that, didn't evaluate it. And the concern there is that obviously with flowability or with an easier possibility of the cement tailings breaking down, that has pretty enormous consequences. And she used the term liquefaction, which was also of concern, particularly with a seismic event. If they're actively piling a bunch of tailings into this and we have a seismic event, that could have a pretty major and devastating impact. She also evaluated and found fault in the DEQ's failure to fully comply with an independent review panel that was created in order to evaluate and assure that tailings facilities are safe. And this actually was this review panel was a law that was passed back in, I believe, 2017, that was in response to the Canadian Mount Polley mine disaster, in which, hundreds of millions of tons of garbage tailings flowed into some pretty pristine salmon streams. And Montana adopted this independent review panel. And it's sort of bizarre, but the first major mining application that we had since then, they just entirely bypassed the review panel and made some arguments as to why, which the judge did not find convincing as to why the DEQ did not require a full and complete application of this review panel, which is composed of engineers, mining engineers that have the credentials to be able to look at the tailings facility and assure that it's safe. And so she found fault in that. She also found some fault in the company's plan to how they're going to be handling the nitrogen and discharges from the facility. This would be basically when you have water in the underground workings, it's going to come into contact with the blasting agent that's used underground. And the water would ultimately be pumped to the surface, stored, treated, and then discharged. The problem being that they could not treat this water to a level that was compliant with the Sheep Creek's I believe it's 0.09 MCL standard for nutrients. And so they tried a workaround, because that was a seasonal standard, June through August or September, of basically impounding this water and then discharging it during the winter months, which was upwards of 0.56 MCL, so 5-6 times as much as the standard. The problem is that once you are inserting this into what they would call an infiltration gallery in the groundwater, it basically moves through this system pretty slowly and unpredictably. And the department did not evaluate the likelihood that the water would actually discharge to Sheep Creek during those critical summer months when we really don't want nutrient discharges into the river. We don't want it regardless, but during the summer is when you really, risk having those algal blooms. They also failed. The judge also found that they failed to consider reasonable alternatives. On that one, specifically on the management of pyrite, which pyrite can have acid generating qualities, and DEQ's own expert evaluated a different type of pyrite related management in which they would have sent a certain portion underground where it would have been stored in a more safe fashion and had less contact with the weather, the elements, water, and whatnot. And ultimately, the DEQ dismissed that evaluation as being both uneconomic and not having a net environmental benefit, but didn't provide any real justification for doing so beyond that. And when you have reasonable alternative possibilities in an environmental project, you need to evaluate them. That's one of the hard book requirements under the environmental impact statement process, and the DEQ just completely dropped the ball on that. They also, one last piece is they failed to really consider actually ramping up the cement mixture in this whole tailings process up to a 4% mixture, and only evaluated that 2%. Which, and then authorized the 0.5%, which I talked about earlier. But the 4% mixture would have potentially dried quite a bit faster and been a lot more stable. And DEQ not only basically stated that there was no net environmental benefit, but did so in a fashion that really didn't take the hard look required. And so the judge found this whole, the permit on all of these specific grounds to be flawed. But she did not yet issue an order as to next steps. What she said was, this is Judge Bitigiri, is that all of the parties involved in this need to issue or need to file briefs with the court, basically saying what we think should happen, the remedy associated with her order. And we haven't really put our heads together about what we're going to discuss, but what we are probably going to request is that the judge issue what's called vacature of the permit, basically ruling that the permit's illegal and no longer in effect, and remanding to the agency. They can certainly start the process over. That'll be our request, but the judge will probably accept that briefing and then have a hearing on it before she issues an order. So we have a little ways to go in terms of wrapping up this whole district court case, but we're really happy with a very strong ruling from the judge. But like I said, the fight's not over. After we fight it out over the remedy and a few other things, there's almost guaranteed going to be an appeal to the Montana Supreme Court. And we're going to need to defend this litigation at the Montana Supreme Court, defend the judge's ruling and the correct ruling. And so that's going to require some serious legal advocacy. So we're prepared to do that. And we're thinking about what that might look like at this point in time. And then, of course, there's a number of other things that can happen. The legislature is probably not a big fan of this ruling. And so I would almost guarantee that come 2023, we're going to have some legislative fights associated with the judge's ruling, particularly in the way that it's based on state statute. So we have also that remand to the DEQ and how they handle that. That will once again start, Sandfire's made pretty clear that they would start their process over again, that they're not going away. And so this fight will go on. It's a marathon, not a sprint. And what I'm starting to learn in my time being here is that these mining fights, they take a really long darn time. So I just wanted to stop and take questions that people have, and I'm just going to look through here real quickly. It looks like, will the state hire outside counsel or have staff handle that? I think that they haven't really, the state has said that they absolutely are going to appeal. Whether they hire outside counsel or not remains to be seen. It seems to me that this administration is more frequently hiring outside counsel to handle some of these things. I've seen it at the Board of Environmental Review. I've seen it at the Attorney General's office. So I would not be surprised if they hire outside counsel, but we will defend it regardless. In terms of who's paying for it, it's the taxpayer. To the extent that the intervener also is involved in that fight, they will pay for their own way. But yes, in terms of the legal defense of the permit, that would be state dollars, as far as I understand. So will MEIC help Montana? Ooh, shoot. Let me go back here. Will MEIC help Montana voters determine who will pledge to vote in favor of the Smith River in the 2023 legislature? Good question. So here's what we can do and can't do. We can't get involved in election-related activity as a 501c3 organization. That would compromise our tax status. However, we do have a very active lobbying, full-time lobbying presence in Helena during the session. And we view accountability on those votes as part and parcel to all of our work up at the Capitol. And so we publish a scorecard that a vote such as one on the Smith would definitely make. And so to the extent that that is out in the public sphere, people will be able to digest that and help to inform their votes. But as you know, we are prohibited by law from really endorsing candidates or getting really involved from a legal point of view. Next question we have is, was any part of the judge's decision based on the Montana constitutional right to a clean, healthful environment? Yes and no. It was a bit sidestepped, but one of our claims was that the failure of the Department of Environmental Quality to apply the independent review panel on tailings storage facilities to this application was actually a non-justifiable exemption from the law and a violation as applied of our constitutional right to a clean and healthful environment. Judges do this thing where if they are able to find a solution for a particular legal dispute in the statute, they will not go to the Constitution. She made reference to it and expressed some concern, but because she found the handling of the tailings storage facility review panel to be incorrect based upon state law and not the Constitution, she just didn't really go there. And so this case is from the order, my opinion is it's probably not going to be much of a constitutional fight, which is okay. I think we're in a really fantastic position. Can Sandfire have its own attorneys work on this? Absolutely. And they have intervened and hired a very expensive law firm that is based out of Billings and has been at both the district court level and will certainly be involved in the appeal. Okay, so what time is it here? Are there any more questions or written, or if you wanted to take yourself off mute and ask them before we jump ahead? And I got another question here from David. A voter guide. I absolutely think that's an interesting idea. We have not done something like that in the past, or at least as in my tenure at MEIC. I don't know if Kim, if you had any experience with that. I'm familiar with other organizations that have done it. It's certainly an interesting idea, and I think that is, probably okay with our C3 status, but it's something that I'll have to bring up with others. And so I think I'm definitely making a note of it, and I think it would have to be more extensive than just the Smith, though. But it's a very interesting, cool idea.
If I could,
I'm making a note of it too, Derf.
Yeah.
If I could just follow up there, I'll just tell you that I'm campaign manager for a new challenger for the House of Representatives who has said for 6 years that if they started to mine there, she'd go and protest, throw her body in front of steamrollers or whatever it took to stop that. So although she doesn't have a voting record because she's a new challenger, she would definitely go on record in support of you if she were to win election in November.
Well, that's fantastic. I'm loving this person already.
I think you know who it is.
Yeah, I think that, yeah, exactly. The more information we can give to our members, the better. And it just has to, me being very cautious about our tax status and making sure that we comply with all the laws. We're careful about it. That being said, I'm aware of other organizations that do those voter guides, and I do think it's a good idea. So I think we'll take this back, David, and we'll have a chat because I think it's a good idea.
Okay.
Another question we have is our constitutional right at risk. This absolutely terrifies me, and yes, it is. There's been recent rumblings amongst certain more conservative lawmakers that the Constitution is a socialist rag and needs to be changed. The ability to do so requires a 2/3 vote of the Montana legislature, which if all of the Republicans were to agree to a change, they would be 2 votes short of making that change. And so this next election could be incredibly important for Montana's future, and in particular, our constitutional right to a clean, healthful environment, and all the other good stuff in there, the right to know, the right to privacy, the right to participate in public decision-making. It's a really fantastic document. And so I'm very concerned about it. And if that's the direction we go in the legislature, it's going to be a really tough fight. But I would encourage everybody to get educated and prepared for this coming election cycle.
Derf, I have a follow-up about that.
Yeah.
The 2/3 vote, would it be a 2/3 vote to hold another convention? Is that how that would work? Or would it just be amending that specific portion?
I think it could be either. I'm going to have to go back and look, but in order.
That is correct. I just looked at it yesterday.
Yeah, thank you.
Hey,
I think that the legislature can pass constitutional amendments, which then are referred to voters with a 2/3 vote, or they can vote to have an actual constitutional convention. So thanks for answering that in the affirmative, Ann. So it is now 5:40. And so I want to give some of our other issues a chance, but again, I am not making this up. This was a big team effort amongst people from all across Montana. And when you sign those things, when you speak at public hearings, you sort of wonder whether or not you're going to make a difference. And from my vantage point, absolutely. When we all pool our resources and focus on one thing like this, we can really make change. And this has been a really fantastic victory. And so now we not have to defend it. The fight's not over, but for a short spell here, we can celebrate. Okay, so I'm going to rattle through the next set of issues that I'd like to discuss this evening, and then I have another set of Q&A for folks. We'll probably be done right about 6:15. The next thing I wanted to talk about is Zortman Landusky. This site has a really long history, a torrid history. It was originally permitted, I believe, back in the 80s, but real serious mining started in the 90s by a company called Pegasus Gold. And most Montanans know the story about Pegasus showing up and mining a bunch of minerals, and then in the late 90s declaring bankruptcy, and a number of their mines, including Zortman, Landusky, and Beale and Montana Tunnels, were pretty dramatically underbonded. And Zortman in particular has some really big environmental impacts. And so the state and the feds at this point have had to spend $86 million in federal and state money, public money, just to get the site sort of reclaimed and managed. One of the big problems at Zortman Landusky is the water has a big part of it is producing acid mine drainage, and that needs to be treated, unfortunately, basically forever. And it also is upstream of the Fort Belknap Indian community. and they have been pretty severely impacted by this. The drainage in which the biggest mine workings are is also their ceremonial grounds and their teepee grounds. And you can literally, when you go there, you can see the pollution basically working downstream into that area. And it's also an area that was very sacred to them. They still go into these mountains and fast. And very recently, there's been some interest from a company called Blue Arc that wants to basically open up some new mines in this rather sensitive environment in which we're trying to manage a lot of the pollution up there. And they came up with a first application that required a pretty significant bond that we filed a legal challenge on. And the significant bond persuaded this gentleman that wants to open these mines to submit a series of applications after that to try and get the bond down. And ultimately, on the fourth round, the Montana Department of Environmental Quality evaluated the whole thing, held public comments through the environmental assessment process. And I have to say that the tribe, Fort Belknap Indian community, won the day and turned out en masse. It was really fantastic to watch. And ultimately, they were able to convince the Department of Environmental Quality that not only is the evaluation really poor on this fourth application, but the cultural resources were not adequately considered. And DEQ did the right thing. And they're required that if that application were to proceed, it would need a full environmental impact statement. Now, those are expensive. And this guy's original idea was to keep the cost down with the bond. And so he's going back to that first application that we filed the lawsuit on. And so we're back to the first application. And so I'm skipping the bullet point a little bit here. Litigation regarding new mineral exploration. So where we are with that is just earlier this week, we agreed to temporarily stay that lawsuit because this mining company, and Ployhar is his name, is one of the gentlemen behind it, has been illegally digging pretty massive test pits on his private property, 7 or 8 of them in this area, without posting a bond or having the requisite permitting. And that caused the Department of Environmental Quality to issue 3 notice of violation letters that they're pretty mad about it, as they should be. And so they've completely stopped any work on that first application and will not accept a bond at this point because they view him as out of compliance with the law. And so we agreed to a temporary stay of that lawsuit pending, this whole enforcement action moving forward. But there's actual satellite imagery where there's these massive holes, and they've gone out and viewed it. And it's a pretty bad deal. This is what you would call a bad actor, which not in a technical legal term, but certainly a mining bad actor. So he also was able to acquire 10 federal mineral claims adjacent to this site very recently, because there was a lapse in the mineral withdrawal that the BLM had issued up there of 2 days. Somehow he caught wind of it. We filed a complaint actually with the solicitor's office at the BLM to try and explore how it is that this whole issue happened. However, they're now in the process of going through the public comment period for that mineral withdrawal. And we would really encourage you to submit comments on it. You can do so. I think Katie's going to drop in our chat here a way that you can support the mineral withdrawal. And we would urge for folks to support the Alternative C, which is the full extent of acreage that was actually withdrawn beforehand. So this would be a status quo in terms of the withdrawal. And that will hopefully give the tribe some a little bit of breathing room, but ultimately what this site needs is a congressional permanent mineral withdrawal. One of the problems with the mineral withdrawals is that they're only 20 years long, and we need to see something that's permanent up there. So that's an ongoing discussion that we're having. So this site leads me into my next discussion. The Zortman Landusky disaster was ultimately what caused the passage of a law in Montana called the Bad Actor Law. And basically what it says is that if you are an executive of a company or a company and you default on your reclamation obligations, you can't get a new mining permit unless and until you pay the state back and pick up your mess. And it just so happens that the chief financial officer of this endeavor is a gentleman named Phillips S. Baker, and he is in the process through a new company that he is now the CEO of applying for opening up 2 mines in the Cabinet Mountains Wilderness. The company is Hekla, and these mines are primarily silver mines, is my understanding. This fight's been going on for quite a long time. But just recently, we noticed that Phillips Baker was the CEO of this company and brought it to the attention of the Department of Environmental Quality and during the Bullock administration, and said, what gives? Why are you guys still processing this application when you have this bad actor law? And the Bullock administration's DEQ agreed with us. They brought basically they stopped any work on that until the company became in compliance with the bad actor law. And they subsequently had to defend themselves in some litigation that we intervened in. And I was actually both surprised and happy that the DEQ pursued that claim. Unfortunately, the Gianforte administration took over recently, and within a year, I dropped the headline in here, they dropped the bad actor claim. They basically said, we're no longer going to pursue this. And they came up with some pretty suspect reasoning as to why, that it would cost money to continue pursuing it, although their outside legal counsel was doing it pro bono. So that wasn't really a good case to make. And we actually have a records request lawsuit against the governor's office to with Kim Wilson on the Zoom here to try and uncover what it is, the reasoning that it went into basically dropping the suit against one of the wealthiest people in Idaho and allowing for this to proceed and ignoring the law. Additionally, we have filed what's called a mandamus action against the DEQ. And so that's basically a legal term of art that says that if an agency is required to do something, you can file a lawsuit that compels them to do so. And the law basically says if Pegasus Gold defaults on this, the Department of Environmental Quality shall not issue a permit to Hekla, is how I would paraphrase it. That shall is a mandatory duty. And to me, there seems to be little in the way of a strong legal argument around this. We filed this, I believe, late last year, and we will have a hearing in front of Judge Abbott here in Helena in late August. It's a little unfortunate. This is going to take some time, but that's where we are with this. And additionally, we are pursuing our records request claim against the governor's office and should have some type of show cause hearing, I believe in May, on that subject. And the governor's office is certainly not willing to give up the records. So it's going to be a bit of a fight. So the last thing I want to touch on which is really important, is this sort of once in a generation chance to reform hard rock mining laws. One of the things that Biden is attempting to do is to honestly try and move our country towards clean energy solutions. And there is a lot of discussion and debate about how that might happen and the mining that might need to occur in order to facilitate that transition. As part of that, he recently created a interagency working group that will make recommendations on the reform of both the regulations surrounding mining on federal lands, hard rock mining on federal lands, as well as legislative recommendations. Now we know where those legislative recommendations are going to end up. They're going to end up in the round file because of where Congress is at. However, there are definitely regulatory changes that can happen under Biden's watch. And the working group is going to be holding a series of listening sessions that we're going to recommend folks speak out at. The listening sessions are sort of focused on different stakeholders, the first being Native American tribes, state and local governments, environmental justice organizations, labor organizations, conservation organizations. And I should have started this off with, the working group is unfortunately composed, it's entirely of agency representatives, but they will be doing this outreach to all of the different constituencies. And anyone can submit comments on this whole process and what you want to see reformed, both in the regulatory side of things as well as the legislative side of things. And I've put that email in right there, and we will certainly be engaged in this. We had a set of talking points that we recently released that Katie can share, and we're going to continue to refine those as we get closer to the deadline. Our hope is really, thinking about it, is really to get some strong changes to the regulations that implement the 1872 mining law, in particular to allow the Department of Interior to say no to certain proposals, which is something that they have a really hard time and legal impossibility doing. And that's to, if there are too many amenities at risk or other uses of the land, empowering and clarifying that the agency has the right to deny mining claims. And I think that would be a pretty significant change to the law and really important. And I think it would be in conformance with the statute, which is the big thing that needs to be, it's sort of the legal test. They can't just make any regulation. It has to comply with the 1872 mining law. So again, once in a generation change, we're going to be pushing this and hoping that we can see some significant changes, at least to the regulatory aspect of public lands mining. So with that, I am going to stop my sharing and answer any questions folks might have and talk about anything that might be on folks' minds. And let's see here. It looks like the chat's been blown up.
It's mostly me. Will has a question in the chat. Is the Hekla mine proceeding while legal action is pending?
Excellent question. And I didn't dive into this because it's complicated, but Hekla doesn't really have a permit at this point because there's two mines, the Rock Creek mine. The biological opinion associated with the Rock Creek mine was actually thrown out by Judge Malloy recently because it failed to fully analyze the full extent of the impacts on endangered species, including grizzly bears. The discharge permit for the Montnor mine was also voided because the Department of Environmental Quality used data from the late 90s in being able to show that the discharges would comply with the law, and it was just stale information. And so neither of those mines have permits that they need in order to move forward. Recently, Hekla announced that they're going to be retooling and taking a different approach to how they're going to be pursuing the mines, including that they're stopping all the work at the Rock Creek mine, and that they're only going to be conducting exploration activities for the time being at Montanore. We don't know exactly what this means. And so we have filed a couple of FOIAs with the Forest Service to better sort of pick apart the details of what it is that they're proposing. One could hope that they're giving up, but it doesn't appear so. They appear to continue to want to spend money in trying to open up these mines. And so I guess we're in sort of a wait and see mode at this point about how exactly they're going to pursue their next steps. And that FOIA was just filed today. So we'll know more in a long time from now because it takes forever. Nick Givok, looks like you got your hand raised.
Yeah, Derf, can you hear me?
Yep.
Okay. Yeah. My understanding, I remember when Bruce Babbitt took a run at the 1872 mining law and lost in court, I mean, in the early 90s. But my understanding is that statute has problems for the industry too. And has anybody reached out to see if there was there would be some reasonable changes to that statute that both conservationists and the industry would agree to?
Excellent question. I think that the appropriate organization that would have those types of conversations would be Earthworks. They really have that national presence and work really specifically on the 1872 mining law. I mean, part of it for me is the license to operate. It's just such an antiquated law and hasn't been updated in, well, really extensively since it was created. And so it's hard for it to pass the, any common person for it to pass the smell test. And so I think to some extent they see that change is certainly coming. And I say that, also thinking, God, it's been 150 years so far and no changes actually happened. But I do think that within my lifetime, there will be some changes, certainly. But in terms of industry outreach, I don't have an answer for you.
Well, that provision to allow permits to be denied would be fantastic, because we've seen so many times where the American taxpayer was on the hook and just at the threat of something. And we remember when Clinton bought out the mines outside of Yellowstone and just the amount of dollars that go into that. Anyway, that's more a comment than a question.
Excellent. Mark?
Derf, I wanted to ask a follow-up question about the Smith River situation. You've indicated the judge has asked both sides to comment in briefs about the next steps. And my question is, does the mining company have any readily achievable way to remedy any of the individual problems the judge has identified? In other words, are we going to end up with it's all or nothing? Either the mine's going to go ahead or it's not, or can they short circuit some of this by solving some of the problems that you guys have shown exist?
Excellent question as well. So in terms of the remedy that's going to happen right now, almost certainly the mining company and DEQ are going to argue in their briefs that the permit should be remanded without vacature. And so it basically will go back and the agency will cross its T's and dot its I's and fix the problematic parts of it, and then allow for the company to basically still have the permit and resolve those issues within a certain time period. And if perhaps it'll be, they'll say, well, if we can't complete it within the time period, then it can be vacated, but certainly we can do that. In terms of fixes to like the actual problems associated with the project, it depends. I mean, so much of this is the price of copper relative to the project. And one of the big things that we're arguing for is a more stable tailings facility that uses 4% cement tailings, which would increase the costs, the overhead associated with this already very expensive mine. They're getting along based upon the fact that they have this purportedly really high percentage in copper concentrate. And that is allowing for them to absorb some of the more expensive overhead associated with an underground mine that's going to be, state of the art and use the cemented tailings backfill and there was not mine, state of the art, as well as the surface impoundment. If the price of copper stays where it is, I think that's true. But I have heard from people, very smart mining people who certainly don't like what I do on a day-to-day basis, that have said that they don't think that this project is all that economic. And so I think that I think the price of copper is going to be one thing. I think that anything that may cost more for the mine to operate, such as the cement tailings facility or changes to how the pyrite is handled, which will also require more processes, may be more expensive. There was no you can't do this from the judge, which is not something you typically see in a judge's order, and not something that we have in the Hardrock Mining Act. It's very much geared towards allowing for companies to move forward in mining.
Okay, thanks.
So, yeah, it depends. Hannah, how you doing?
I'm well, Derf. Just in regards to Hekla and their exploration for Libby, can they even do that with the bad actors? Like, can they even do?
Right. Well, no. And that's our position. But DEQ has dropped the bad actor suit and is no longer pursuing it. So until we have an order from the judge finding that DEQ is in the wrong, and in fact that they cannot issue an exploration permit or allow for one to remain while that bad actor status is in place, they can at their own peril, at their own risk, pursue that exploration, which is kind of unfortunate that we have this hearing all the way until August, that we have to wait for it. But right now they can proceed. But there's also the question as to whether or not the activity that they're conducting up there is within the confines of their original exploration permit. And so we're trying to figure out what it is exactly that they're proposing.
Yeah, because then that brings in the grizzly bears too.
Yeah, absolutely.
Thank you.
Derf, let's, David's had a question in the chat for a minute, so let's jump to David real quick.
Okay, I was just going to repeat the question live, and that is, can you post a list or rattle off a list of journalists, newspapers, independent bloggers, who are tracking these issues and writing about them, or that we could support in terms of subscriptions to these newspapers, because they're actually publishing letters to the editor and opinion pieces from MEIC and partner organizations?
Yeah, well, we work with all different types of the press. I am particularly impressed these days with the Montana Free Press.
I thought you'd say that one.
they don't have annoying advertising, and they have journalists who actually do really, I think, more in-depth reporting than what we're used to with the Lee Enterprise and some of the other papers at this point. So I'm a, I don't know if I call myself a member, but I sent Montana Free Press $40 last year, and I plan to do the same this year because I think that, it's sort of citizen-driven journalism. So that's one. Another one that I've recently been pretty happy with, well, just in terms of her stories and digging into natural resources issue, is Laura Lundquist in the Missoula Current does a really fantastic job. She really digs into issues, and she's a good reporter.
Thanks.
I'll just speak to the other half of your question in the chat, David. I find that I feel like we have a little bit of harder time getting into papers in the Flathead region. And so if anyone has contacts or suggestions for how we can get a little bit more of a toehold up there with some of those opinion pieces, I would love to hear them.
Absolutely. Steve, how you doing? Nice to see you.
Yeah, good to see you folks. Thank you, Derf and Katie and all you folks at MEIC for all that you do. I know it's not always happy work, right? It's down in the trenches, but we need our lower axes now more than ever because the lower axes we feel are getting fewer and farther between. But so thanks again. Speaking of copper mines, I'm just wondering if you have heard any intel about the Rio Tinto Kennecott exploration up in the Garnets, the West Garnets, essentially between roughly Clinton and Potomac. You know, they've been up there drilling for years, quite deep and exploring, and they have a lot of the mining rights or the mineral rights up there, and not a lot of activity of late, but I'm just wondering if you have any intel about that.
I had
project.
Yeah, I did. I went to a public meeting actually up in Greeno at one point that Rio Tinto had, and sort of poked around and listened to what they had to say, tried to understand some of the geology. And I know that they have been doing, that was back in 2014. I know they've had a number of field seasons since then, but I want to say that they sort of pulled back at one point. And so I'm just not sure of where the status is. It's not on my radar in terms of something that's on the front burner right now. But if you hear of something, certainly let me know, because it's, something that we would certainly be interested. That's the Copper Cliffs area. Is that?
Yeah, the Copper Cliffs.
Yeah.
It's an old mining district right up by Garnet Ghost Town. And I quite certainly haven't done any test drilling for about 2 years, but it seems like they got the information they needed. And my take was that they were just waiting for the price of copper to come up high enough to where it could be affordable. But, I know it's a very deep deposit too, like roughly a mile down.
Yeah, that's what I remember with the geology, is it was like the bottom of a magma chamber that like this, it was an old volcano and they need to get down to where it opens up. It was really interesting to hear about. But I just haven't heard anything recent.
So for perspective, is the Smith River proposed mine, is that deposit much closer to the surface?
My recollection is it's closer. It's about 3,000 feet. So it still is a fairly deep deposit, but not as deep as if it was a mile for the Copper Cliffs. What they're pursuing, it's not as deep. And it depends on where you are in terms of the access of the ore body that they're pursuing, the Johnny Lee. Looks like Mark's got another question.
There we go. I was responding to Katie, and I don't have any real private information about this, Katie, but if you're looking for sympathetic reporters in the Flathead area, I know that the dominant local weekly newspaper is called the Flathead Beacon. I see that often, and Tristan Scott seems to be the prime reporter for doing in-depth pieces. And my impression as just a consumer is that he seems to be not only balanced, but maybe favorable toward progressive issues. So he'd be the person I'd call if you have something you want to get on there and an opinion in the form of an opinion piece or otherwise.
Thanks, Mark. You're the second person who's told me Flathead and Beacon in the last couple minutes. So
Okay.
That's a great endorsement. I appreciate it from both of you.
Wonderful. Any other questions from anybody?
Katie, I'll just put one out there. The City Lake Pathfinder, which is, a small paper, but they have a column they call A Place for All. And then they also have a new column for nonprofits. So you might contact them and a lot of the local environmental groups and conservation groups have, a column in there roughly, every other month they rotate through. So it might be another opportunity. I don't know what their readership is.
That's great. Thank you.
Excellent.
There's also Citizens for Clean Energy, which I serve as vice president. If you want to send us any information or press releases to me or Rich Liebert, we'll be happy to give you space on our social media channels and website as well.
Thank you. Awesome. We're big fans of Rich Liebert in our office.
Okay. Well, we're getting towards the end of our allotted time here. I'm happy to stay on and answer any questions you might have. I wanted to put a plug in for something that MEIC's committed to today. We're going to be hiring a land use type job. Katie, what's the specific job title again?
It's a Sustainable Communities and Planning Advocate.
So Montana is experiencing some pretty rapid growth, and we are also, we're hearing a lot of saber rattling in terms of changes to a lot of our land use planning laws, and we're trying to get ahead of it. So Katie, if you want to drop that into the chat, if folks know of anybody that may be interested and qualified for that position, we'd certainly be appreciative if you were able to share it with them, because this is something that is important, and we want to make sure that conservation has a voice in that whole argument, and how we might, we have a very rapid growing population and a lot of interest in development.
How senior a position is that? Are you looking for somebody with 30 years of experience or 3 years?
I think that we specified 2 or 3 years as required, but you'll have to go back and look at the exact. I think we're looking for the right fit more than anything. Somebody who has a lot of land use knowledge would be helpful, because it's really sort of a wonky area of the law.
Okay.
Policy.
All right. Thank you. Great work, guys.
Any other questions? Sam, it's nice to see you, by the way. Thanks for
sorry,
dropping
I
in.
can only make the end, but thank you so much. You guys are awesome. Really, really awesome work.
Thank you.
And this will be recorded, is that right?
Yep.
Cool.
Katie, will you send that out to people somehow via email or something?
Yeah, it'll also be on our YouTube, and we have a page on our website for meeting videos. So if you ever miss a meeting, you can come to this page. It's linked in the top menu, and you might find it there. So
great. Well, thank you, everyone. I hope you have a fantastic rest of your day and going into the weekend. Hopefully we'll get some nice weather, and we will have another one of these updates in about a month or so.
2 weeks.
2 weeks. Okay.
We'll be talking about clean energy with Ian Lund, who's our new clean energy advocate. So if you have any burning questions and want to send them to us in advance, so we can make sure that we are addressing what you're interested in, please do.
Cleanly burning questions.
Only cleanly burning, exactly.
Thank you. Great job.
Everybody.
Good work.
All right, thanks everyone.